opening panel, which will be chaired by the Honourable Sir Robin Knowles, or I should say Sir Justice Robin Knowles, who is the Judge of the High Court of England and Wales. Sir Justice Knowles sits in the Commercial Court, the Administrative Court, and the Court of Appeal within the within the Criminal Division. He is also the Civil Justice Council and chairs its work on access to justice for those without means. And if that isn't enough, in his spare time, Robin has spent most of his career involved in the encouragement and coordination of legal pro bono, both nationally and internationally. Indeed, in 2007, he was awarded a CBE in recognition of his service to legal pro bono. Robin, over to you. Can I please now ask you and also invite the panelists to turn on their cameras and join us, please. Welcome all.
Yasmin, thank you very much indeed. And I'm hoping 2 more of our panel will come on screen. Thank you.
I am trying, but I believe Adrienne needs to put my video on as well. Yes, now I can. There we go. Yes.
Perfect. Perfect. Well, thanks again to Yasmin, and thanks to A4ID, and thanks to the panel that I'm about to introduce. Just a few things about the logistics of this session. After brief introductions, each of the panelists will address this conference, and I'll follow that address with a couple of questions to each of them. Then we're into a broader discussion across the panel, and I hope that those attending the conference will help direct and contribute to that discussion by suggesting questions through the chat Q&A function. I'll bring those questions in as best I can, but please contribute in that way. Now, so far as our panel are concerned, they have one thing in common amongst others, and that is global experience. As it happens, our panelists are physically at the moment in India, Amsterdam, Washington, and Scotland. Justice Anjana Prakash is a former High Court judge in India. She is now a senior advocate of the Supreme Court of India and is widely published in access to justice and rule of law fields. Jeroen Ouwehand is the global senior partner of Clifford, the law firm that spans 5 continents. His technical expertise spans financial and oil and gas work in particular. But he's also been instrumental in the environmental, social and governance initiatives at Clifford Chance, and in causing that law firm to sign the UN Global Compact for renewed global cooperation. Julia Brown-Miller is from the World Bank, and there she helps lead on women, business and the law. She champions research across no less than 190 countries each year in those fields. And Ian Duddy is from the Foreign Commonwealth Development Office. There, Ian leads on human rights and the rule of law. He's the head of human rights and rule of law department in the Open Societies and Human Rights Directorate. That powerful panel is very welcome indeed. And first remarks will come from Anjana. Anjana. You're on mute, Anjana. If you could come off mute, that would be great.
Oh, I'm so sorry. I hope you can hear me now.
Loud and clear.
Thank you, Justice Knowles, for such a nice recommendatory, I would say, introduction. I didn't deserve so much anyway. Good morning, good evening, good afternoon to everyone. I'm really honored to speak at this August gathering, and I hope my note will be worth the invite. So I begin now. As many of you would know, Article 21 of the Indian Constitution guarantees that no person will be deprived of his life and liberty except according to procedure established by law. Now, this establishes the foundation of rule of law in India. Where access to justice is concerned, Article 39A, even though it is included in the directive principles of state policy, which is not justiciable, it obligates the state to operate the legal system so as to promote justice on the basis of equal opportunity and free legal aid by suitable legislations. Accordingly, all states have a legal services authority in place to ensure this goal. This is the legal position in India where rights and duties are concerned. Since these rights and obligations are undoubtedly seriously impacted because of COVID, the efficacy and reach of such statutory bodies, including courts, require an objective critique. Looking at the figures of National Crime Bureau reports, one finds that there is a constant increase in number of criminal cases registered even while the figures of disposal of cases have halved, if not less, in each high court. I'm talking about high court because that is the best equipped in every state to deal with a situation like COVID, and that is an urban area. The statistics of disposal of cases in Patna High Court are 1,17,912 in 2019, which dropped to 51,624 in 2020. And in 2021, it is 20,079 up till now. That is 6 months ago. So it will be around the same figure. This disposal is of 210 working days by 19 judges. We have a sanctioned post of 53 posts in the Patna High Court, but we have only 19 judges functioning. So even in normal times, access to justice would have been seriously impacted. And during COVID times, obviously more so. One alarming report suggests that the National Commission for Women received as many as 1,000 calls in a month. And you'll be surprised to know that for family courts, counseling centers are closed as of now because of COVID. So while the numbers of domestic violence is increasing, there is no redressal of any kind. Most of you would be also aware that India is the seventh largest country in the world and the second most populous. And we have a federal system. For administration of justice, the structure is designed to function to reach the remotest corner. And this is by a hierarchy of courts. Supreme Court is located in Delhi, which is the apex court. As for each of the 28 states, we have a high court, mostly in the capital area. Below them are the district courts and the magisterial courts. Each high court has administrative control over its district and magisterial courts by its set of rules and procedure, which is formulated with great exactitude. The functioning of the courts is thus believed to be a well-oiled machinery. On account of the hierarchy of courts, the mechanism by which cases are managed in India is somewhat complex. Since even while a case may originate at a certain level, it achieves finality after going through multiple level of courts. And for each level, one requires a separate and unique infrastructure in place, which is, once again, in the present system, it is lacking. And because of COVID, it has been seriously impacted. So the multiple pressure built upon this account has to be seen in the Indian context, where majority of litigants are illiterate, their miseries compounded with immense financial and caste inequalities. Such an unsophisticated marginalized litigant with meager means has a limited choice of legal assistance. The lawyer he can reasonably afford is himself strained beyond limits, having limited access to technology. In this backdrop, the insistence of courts to depend only on technology to achieve its purpose is denying access to justice. Thus, such lawyers and litigants are twice disadvantaged, once by COVID and secondly by the administrators of justice. The global pandemic has no doubt acted as a catalyst for immediate response to a crisis. But what is required to be seen is whether the legal trend has only geared to depend upon technology as the ultimate savior. In my opinion, the perception that technology can offer a solution is incorrect. Technology by itself can only be a means of access to justice. It cannot supplant justice. And for this reason, purely in the Indian context, we need to ask ourselves whether we are even attempting to identify the gaps in understanding and capability. Unfortunately, the judiciary has thought of evolving a system of virtual courts alone as a solution to remain relevant, thus increasing dependence on technology, which has not only impacted the quality but also quantity of litigation. Moreover, it is seen that leveraged technology are better prepared to support clients even remotely when pandemic began. This has created a professional inequality, further exacerbating the divide between the equals and unequals. Reality of economics is brutal and may be difficult to behold for those immune in their comfort zones, but it must be seen for what it is in order to reduce its effect. Once we do that, we have to begin an inclusive consultation with the substantial stakeholders such as members of the lower judiciary, lawyers practicing at various levels of courts, the court staff. With such crucial input, the administrators could then seek technical assistance to address the shortfall of access to justice. This is especially important since no one knows till when COVID is going to last. Unless we look for long-term solutions, there may not be any hope. Thank you. I'm sorry I'm ending on a dismal note.
No, and Anjana, and thank you so much. A lot of resonance in those remarks for other countries around the world. You mentioned that for the courts to impose technology-based systems can leave some in a place of increased disadvantage. And you contrasted the question of technology as a means of access from the question of actual supply of justice. But can I take you to this question? In the future, can you see ways in which technology would be part of the solution for greater supply of justice? In the event that technology was more available to the population and thus open as a channel for the contribution of legal advice to the population. Do you see that as a possibility on a future horizon?
Most certainly, sir. Most certainly. But I would think, that there should be a universal application of technology. That access must be provided to everyone. It's not, it should not be only in the urban areas that lawyers like us, sitting in Delhi, we can get access to such things. But the point is, you have to think about rural areas where the main litigation starts. So you have to have that, you see. The input of litigation begins in the rural areas, in the district areas, where I think it is more important to have, access to technology. Of course, here, you certainly need it in urban areas. We could go with a hybrid system, but then you have to provide that to them. The focus is right now only on the urban areas. And this is my grounds. This is my concern.
Thank you very much. No doubt, and I hope we will come back to that further in the course of the conference. Can I move next, please, to Jeroen for your remarks?
Thank you very much, Sir Robin. I mean, first of all, let me briefly introduce myself. As Robin already did, I'm a senior partner at Clifford Chance. And when you explained my background, you mentioned experience in the oil and gas industry, also in the finance area. I'm actually a litigator by background. So for me, in a way, having spoken often in advocacy role towards the bench, it's nerve-wracking to be on a panel with two very senior judges, but I'm used to being in front of judges in a different capacity, so it's an honor to be with you on this panel like this today. You mentioned various of my roles. I will very briefly, in 4 or 5 minutes, explain a little bit what I do and what we do as a firm around pro bono community work, and in particular, access to justice. So one of my roles is I chair within the firm our so-called Responsible Business Board. And that is the board that really drives our 4 pillars of responsible business. And one of those pillars is really around community and pro bono. Now, just thinking back, I've been a partner in our firm for over 20 years. And as a young partner, I coordinated our pro bono activities in continental Europe. I'm from the Netherlands, Amsterdam. And I'm glad to say that if you look how much we've moved and how much we've professionalized in those two decades, now that I'm in my new role, can see it again, we have really come a long way. And I think that is true for the whole legal community, which is a fantastic development. So our pro bono focus is really around the Sustainable Development Goals of the United Nations and around 3 pillars: access to finance, access to education, and finally, and importantly for today, access to justice. We do that around something called our theory of change, which I believe is quite a unique system whereby we have very clear key performance indicators working together with close to 20 NGOs on the Sustainable Development Goal number 17, so the partnerships. And Advocates for International Development is an example of how we work. It is one of our global relationship NGOs, and Clifford Chance is one of the founding members since 2005, and 2 of our partners are actually board members. Now, what I think is interesting to see is how we've dealt with pro bono throughout the pandemic. And I'm glad to say, like everything else, we have really been able to carry on, and we've had to adapt our methods of delivery, and maybe we can talk about that in a bit more detail later on, because that also, to me, is relevant to the whole access to justice question and the innovation and technology question that Supreme Court Justice Anjana just referred to. But in our pro bono work, we really focus on something called now SDG+, and it's really a greater focus, not just on several SDGs, but a greater emphasis on the rule of law for the reasons we've heard in the introduction today, and the World Justice Report showing that it's gone backwards in the past 3 years. We feel, obviously, as a global law firm, a greater emphasis on the rule of law and on Sustainable Development Goal number 16 is really where we can put a lot of emphasis. As I said, we've really, during the pandemic, adapted our method of delivery. For example, working with Advocates for International Development in our work with the East Africa Law Society, where we've been giving training. Initially, that was in person on the United Nations Guiding Principles, but we really moved to remote webinar-based workshops on responsible business. I think one of the great statistics I saw this morning when I looked into this is that during the pandemic, there has been a 17% increase in pro bono hours across the firm during 2021. So in the pandemic, there has been even a greater focus on pro bono work within our firm, which I think is a great development. I would argue when it comes to access to justice and the rule of law, and it's very interesting to listen to Supreme Court Justice Anjana just now, really for the use of innovation. And whilst I recognize it can only provide access to justice and can't supply justice, I do believe a lot of the developments as we build better or build back better can be around innovation, whilst I fully recognize that we should clearly not just focus on urban areas. So I see the challenges between the haves and the have-nots if we do everything around technology. But I do think we've learned a lot during the pandemic and all have become more familiar with the use of technology. We should use that to our advantage. And indeed, as we all know, there has been a clear threat to the rule of law during the pandemic. And I think innovation can be part of the solutions as we come out of it. I have many other things to say, as Robin, but I think given the time, I will stop there. Thank you very much.
But thank you, Jeroen, very much indeed. And that is, if I may say, an impressive insight into the contributions that Clifford Chance has striven to make, including in the pandemic. Can I ask you whether you combine with other major firms so that the effort of major firms can be collective, so that the effort can be greater than the sum of its parts?
I think that is a great question. I think let me take one step back. We collaborate a lot, not just with those close to 20 NGOs we work with under SDG 17, but also and increasingly with many of our sort of fee-paying clients. And I say deliberately like that because we consider the NGOs we work with at a completely equal footing with our sort of more commercial fee-paying clients. But what we see increasingly is really our larger global clients really want to collaborate and work together to scale up and work with joint focused. I'm trying to think hard whether I can think of a concrete example where we do that together with another major law firm. We obviously see major law firms working together with some of the same NGOs that we do, and Advocates for International Development is a great example. And as you know, you work as an organization with many, many global law firms, and we think that is great. One thing I will say is that for us, it is never a matter of exclusivity. It's never a matter of, as it may be in a commercial setting where you try and win, so to speak. In this environment, obviously, it's all about working together. So any opportunity to collaborate is fantastic. And where I see opportunities to work together with NGOs, I'll give one example called the Hague Institute for Innovation of Law, which does a lot around innovation and access to justice. We've started to work with them as Clifford Chance, and immediately when I discovered the benefits of that, I introduced them to Allen & Overy, which is one of our, another large global law firm. So in that sense, we see collaboration. Yes, absolutely.
Thank you. And could I ask you one other thing? Over and above of some of the activity that you've already kindly mentioned, is there a project in which Clifford Chance has been engaged in the course of the pandemic that has particularly striven to reach to the rural need, not the urban need? Are you able to identify a project in that regard?
Yes, for example, what we do is we have one project called the Cornerstone Project, where we did almost after a survey in the firm, there were people could elect, and we decided in the end, we landed on providing support over 5 years of more than £1 million per year to Rwanda, centered in Kigali. But we do a lot of projects together with the Survivor Fund, which supports genocide survivors. And that goes throughout, that is not just Kigali, but also in the urban and particularly in the remote areas. And so a lot of our work is not just focused on urban areas. And I think the work we do in Rwanda is an example of that, working with the Survivor Fund. A similar example I could mention is the work we do with women in Africa, where, and now actually, the remote working environment has given us greater opportunity to spread our wings, but I fully recognize the challenges that obviously not everyone in rural areas has access to technology.
Jeroen, thank you very, very much indeed. May I then move to Julia for the next contribution? Julia.
Yeah, thank you so much for the introduction and overview, Sir Rob. And as mentioned, I work for the World Bank's Women, Business and the Law project, and we research the legal framework and how it impacts women's economic opportunities in 190 economies. And here I really need to thank also A4ID for doing an amazing job and for being our global partner for many, many years, because we wouldn't be able to collect all the data that we publish and do all the research without the help of pro bono legal experts in all the 190 economies that we cover. And A4ID is always helpful in making these connections. And so our annual index and our annual report find that there are legal barriers for women to access the labor force. And the main finding, I would say, and which is important to keep in mind, is that on average, women have just 3/4 of the legal rights afforded to men. So only 10 economies worldwide give really equal legal rights to women. And now that we're undergoing this pandemic and seeing the impact of the pandemic, we really find that the need for legal reform is even more urgent today, because the pandemic is widening existing gender inequalities under the law and in the world. And there are two main reasons that we see and why the pandemic has disproportionately impacted women's work. One is that female-dominated industries like retail and services are heavily affected by the crisis. And the other reason, and I'm sure many of you can relate, just being connected from home right now and maybe having a family member with you. So the other reason for this negative impact is an increase in family caregiving responsibilities due to kindergarten or school closures. And that forces many women to scale back or even leave the labor force altogether. We know that pre-pandemic, women were spending 4.5 hours a day on unpaid work on a global average, but men were spending less than half of the time. And so a few examples from our research findings supporting this. The first point, negative impact of the pandemic on the jobs that women do, or we call this sectorial job segregation. Women, Business and the Law has shown that in 90 economies, the law still restricts the pool of jobs that women can hold. For example, in Ethiopia, women cannot work in jobs deemed dangerous in the same way as men. India, Justice Anjana, you know that there are restrictions on women's work in factories and mining and at night. And also in the UK, that was the case until 1989. So we still have so many jobs that women don't even have access to. The second point I mentioned, extended caregiving responsibilities. And here we need to look how the law can support women through leave policies, maternity leave, but also how to bring in fathers to take on more care work. Now half of the economies in the world do mandate some form of paid paternity leave, so that's really great news. But the median duration of that leave is 5 days, while maternity leave is 98 days globally. So really lots of room how we can bring in fathers to take up more care work. And while we were collecting the data for our last report, the pandemic had just started. So we looked also on government responses to support working women. And there are 3 themes that have already been brought up a little bit in this panel. The first one, of course, childcare, additional support for working women to provide childcare. We have seen new leave policies that have been introduced around the world in 40 economies, including the UK, having done interesting work providing tax exemptions, for example, for childcare centers. But yeah, most of these measures are around high-income economies, and they also don't reach women in the informal sector. And the second area is access to justice, exactly what Justice Anjana was talking about, introduction of remote access, which of course we see as a positive measure, but here bear in mind also the internet gender gap, women not having access to the internet or mobile phones in the same way as men. And the third area, of course, domestic violence. We already heard that sadly there was a huge increase in cases reported. And so we're looking what measures are available to women survivors.
Julia, thank you so much for that. Can I follow with a couple of questions, really probing your expertise? Justice Anjana mentioned the difference between the urban context and the rural context. What I wondered is whether your research reveals that access by women to technology is different in the rural as opposed to the urban context. I'm thinking of technology as a means for conveying access to justice, but at the level of the technology itself, any insight from your work?
So again, we look, of course, across 190 economies, and we usually focus on the legal framework applicable in the main business city, but we're fully aware of the gaps between urban and rural areas. And again, we see it as a positive measure that this uptake in technology also enables women to access justice. We have seen a few cases where divorces, child alimony, child maintenance cases were successfully tried through technological remote access. Also, many economies that introduced electronic case filing, which of course can also enable women in remote areas because you don't have to go in person to the court. So of course that is a positive measure. But I think what we're seeing is that it should be this mixed approach, that family cases on domestic violence, protection orders, that is declared urgent, essential. So even during court closures or reduced staffing, these cases should have priority. And we've seen that in 72 economies around the world. There were like regulations issued to that extent. And then of course also that we as the international community come together and support access to technology for women, and always bearing in mind this gender gap in the uptake.
Thanks, Julia. One other question, if I may, of a different type. Your research will identify, no doubt, where pro bono contributions would be particularly needed or effective. When it does, how do you bridge what you've identified with your research and actually bringing in pro bono or other contributions to make a difference?
So I would say it's a two-way street. So we, of course, rely on these wonderful pro bono contributions from 10,000 legal experts all around the world, because we couldn't, have access to all these laws, all this data that we publish. So we collect our data through questionnaires on family law, labor law, and violence against women legislation. And lawyers, legal experts around the world help us to collect this data. So that's how we benefit. But of course, our research is, it's a global public good. We encourage advocates around the world to use it to promote reform on women's legal rights. Because what we also can show with our research, and I really encourage you to download it from our website, you will find snapshots on every single one of the 190 economies that we cover, highlighting the gaps and opportunities for reform. So if you look at that, if you are lobbying, advocating for legal reforms, for better access to justice, economic empowerment of women, you can use our data, of course, to have a snapshot of your own economy, but also you can compare it with other economies in a similar system. Successful legal reforms, we publish deep dives on that. And of course, also, you mentioned at the beginning of the panel, and I think that's the most important part of our research, is the economic case for gender legal equality. Because by now we're not only talking about human rights and women's rights as human rights and the rule of law, we're talking about smart economics. And that for 12 years we have been making this case by using women, business, and the law and the research on gender equality under the law and correlating it with economic outcomes for women. And what we're seeing constantly is that economies with a higher score on our index, with better laws for women, more gender equal laws, also fare better in terms of economic outcomes. There is a higher female labor force participation. There's a lower gender wage gap, women in better employment. And lastly, also more women parliamentarians. That's an outcome that we've seen in our last report. And more women parliamentarians, of course, means also there's better laws adopted for women. We've seen uptake in domestic violence and sexual harassment legislation, for example. It's really the use of research to advocate for legal equality.
And Julia, thank you. I'm going to shamelessly ask you one more question, if I may. From your vantage point at the World Bank, I imagine, subject to correction from you, that microfinance and microinsurance has made quite a difference to the position of women in parts of the world, especially in an economic context. Do you think that there's a way in which that development can include access not just to finance and insurance, but actually to justice?
It's a huge question. Access to finance is huge, of course, to promote women entrepreneurs, because we know there's a huge global gender financing gap, women not having access to finance, and that prevents their entrepreneurship opportunities. In terms of, I would see it again in terms of legal reform. What are the laws that need to be reformed? And we actually measure, on the one hand, laws that promote women's access to finance through non-discrimination legislation, for example. If a woman has been prevented in receiving credit, then there should be a law that that prohibits that and makes it, you know, subjected to sanctions. But again, also you need to look at the greater legal framework that actually prevents women from accessing finance. And here we're looking at unequal property laws. We know that 40% of economies around the world still limit women's access to property in terms of unequal marital regimes, where it's the husband that administers marital property, or unequal inheritance rights. And that is an issue still in many countries where daughters inherit less than men. And so that prevents their economic participation from the get-go. Here again, a wonderful example from India that reformed this law actually in the 1990s, where inheritance for sons and daughter was equalized. And as it was done state by state, we can see the effect. And the effect is just multiple, that women who benefited from the reform, their daughters had better education outcomes, the houses had better sanitary equipments, and eventually more bank accounts. So really, we have to think about these legal and actual ramifications of legal reform that are just enormous.
Julia, that you've been very, very decent in responding to the questions. Thank you very much indeed. Let's take the fourth contribution, if we may. And Ian, over to you.
Thank you. Good afternoon, good morning, good evening, wherever you are. And thank you to Justice Knowles and to fellow speakers. Before starting, just allow me to say thank you very much to you, Justice Knowles, and to Advocates for International Development, both for bringing this event together and for the work you do on the UK's behalf overseas. Roll UK is A4ID's flagship UK aid funded programme, and we believe that it's genuinely innovative in its approach in harnessing the UK's world-renowned legal expertise towards our development mission to strengthen the rule of law globally. Today, I've just been asked to say a few words on this panel about the UK's aid and development agenda and the rule of law's place within that. So I just wanted to touch on three quick themes. Firstly, the Sustainable Development Goals, which I know Jeroen has already mentioned. Secondly, the creation of the Foreign, Commonwealth and Development Office. And thirdly, what that means for the UK government's strategic approach to development. So just starting off quickly on the SDGs, the Sustainable Development Goals. I firmly believe that these goals provide the purpose, the principles and the yardstick for all our development efforts. And it's a huge agenda, from food security to ocean health. But I think their value comes from being adopted by all UN member states. So from 2015, they were agreed by all UN member states, and a real emphasis on global partnership. And so the Sustainable Development Goals are intended to move us away from that sort of old paradigm of donor dependence or a north-south divide or a rich-poor divide towards genuine collaboration. And having adopted the goals, the UK also has an obligation to report on its progress towards the Sustainable Development Goals, just as Sierra or Bangladesh or other countries would have to do so. So the work of my department, Human Rights and Rule of Law, is squarely focused on the Sustainable Development Goal number 16. And just to remind people of what that says, SDG 16 talks about the promotion of peaceful and inclusive societies for sustainable development, providing access to justice for all, and building effective, accountable, and inclusive institutions at all levels. And we've just been reminded by Lord Ahmed at the start of that today's discussion, the FCDO minister, that SDG 16 needs to be at the heart of all of our diplomatic and development engagement. Secondly, let me just turn quickly to the creation of a new government department, the Foreign, Commonwealth and Development Office. I think it would be fair to say that historically, perhaps the UK government's international engagement around the justice sector has been somewhat underplayed. We have not always been a significant donor in this field. And in its 2015 review, the Independent Commission for Aid Impact pointed to a number of areas where our aid could have been more effective. And on justice and rule of law, what we're now trying to do is bring together our diplomatic and our development tools to deliver greater impact. And this is what the new FCDO, bringing together the foreign and the development, aims to do more collectively. So responsibility for aid programs in the justice sector now sit within the same team that is also trying to influence diplomatically the international system. Key international and multilateral bodies like the UN Human Rights Council or the Council of Europe. And in addition, our ambassadors around the world, and in my previous role, I was ambassador in South America. The idea is that they have much better oversight of all the range of activities and programs that are taking place in the countries where they are working. And so the idea is to use our aid and influence in a more integrated way to ensure that we reach our goals. Thirdly, looking ahead, just to say a few words about the UK's strategy on rule of law and justice, and what this looks like as we move out of the pandemic. The government published in March this year its integrated review. It was entitled Global Britain on a Competitive Age. And this really is a strategic forward look on the foreign policy, defense, security, development agenda, and it's probably been the most sort of sweeping review we've had on those pillars in the last couple of decades. And a major theme of the integrated review has been the central importance of what the Prime Minister calls open societies. So the argument that liberal democracies and free markets remain the best model for social and economic advancement of humankind. And so after the government published those strategies, departments like mine now have the obligation to implement and promote the strategy. And it's probably worth explaining what we mean by open societies. And the Foreign Secretary recently addressed this in the Aspen Security Conference when he talked about the UK being a force for good in the world. So drawing together economic, military, diplomacy, and cultural advantages to increase security and living standards around the world. And the Foreign Secretary is very clear that the rule of law needs to play its part in that force for good, and particularly given his background as a lawyer, with a view that the British tradition has a global appeal in terms of promoting rule of law. So we are very much committed by the integrated review to building the capacity of justice systems and institutions by drawing on the reputation of our legal systems and services and our common law system. And we do maintain a significant donor budget. We continue to remain one of the world's largest bilateral donors, with around £10 billion for this year. And we know that there's a big job to do post-COVID and encouraging economies to recover. So just sort of let me sum up by sort of what this means in terms of the rule of law and justice agenda for the UK for its diplomacy and development. So number one, we will continue to be guided by the Sustainable Development Goals. We have an obligation, we signed up to them in 2015 like all other UN states, but that will require genuine and collaborative partnership. And that's why I'm so grateful and thankful to the organizations represented here and for the work that you do pro bono around the world. I think secondly, the FCDO has opened up new opportunities to integrate our diplomatic and development toolkit. So really trying to harness both those elements to bring together the best of the legacy departments of the Foreign Office and the Department for International Development. We really are trying to be a unified voice and a stronger voice. And thirdly, the integrated review, the government's strategy, has set out clear ambition for UK leadership on rule of law and justice, and drawing on our domestic legal expertise to help and work in partnership with others. And I think what makes this an exciting agenda is that A4ID and Roll UK are working, at the intersection of these principles, partnership, integration, and leadership. So I'm also very much looking forward to building on this conversation, listening and learning about how we can work together, because we have a significant agenda to achieve by 2030 with the Sustainable Development Goals sort of deadline. Thanks.
Ian, well said, and that tripartite emphasis on partnership, integration and leadership, I can tell rightly resonates. Danushka, in her thoughtful remarks at the beginning of the conference, recognized that rule of law does have different meanings in different parts of the world, at least as things stand. Does that matter, in your view, to the success in engagement? Is there a way to make sure that there is successful engagement despite that?
Yes, I think it's a very interesting question about how do we define the rule of law, because it might mean different things to different people. I think from the UK standpoint, we will take sort of three, if you like, guiding principles in terms of what we mean by rule of law. And Danushka touched on some of these. So power is not exercised arbitrarily, that there is equality before the law, and that fundamental liberties are secured by the courts. And I think that the challenge we face is ensuring that rule of law does not become rule by law. And but at the same time, in order to have real impact and change at the country level, it does need to be a partnership. We do need to understand kind of the cultural context. In order to be able to move the dial in countries, it does need to be a partnership. And really understanding the context in which we're operating, and listening to our partners about what they think the rule of law means to them, and starting that conversation. I think sometimes the UK and perhaps some Western governments sometimes accused of being quite dogmatic. I think it's important that we have some clear principles about what the rule of law means from the UK point of view, and we defend them and promote them. But that doesn't mean that we're not able to listen at the same time.
Yeah, and thank you very much indeed for that answer. We'll now move into a discussion across the panel, and as I touched on earlier, I hope that those who have kindly joined the conference will contribute questions or comments that I can bring into this discussion. Please use the Q&A function to do that. And I'm told that there's a facility to vote up questions where you think they particularly deserve emphasis. So please make the most of that. I've seen some of those who are kindly joined the conference, and there's a massive level of expertise in the audience, not just on the panel. Can I switch across first, given the title of the conference, Pro Bono for the Rule of Law, just to focus on pro bono for a bit in its own right, but in that context. And the question, and perhaps I could start with Jeroen on this, is whether pro bono has become a part of being a lawyer, not just something that a law firm will offer and make sure it offers alongside its other activity, but something that is really part of every person who practices the law. Jeroen, where do you think we are on that?
I think we are, thank you for that question. We are a long way, but I would be exaggerating if I professed that it is something that every lawyer does and sees as a standard part of being a lawyer and of their own education and training. Personally, I think it should be, for many, many reasons, including, apart from all the good reasons and the support we're giving through it, is that I think it is really part of the overall training experience of any good lawyer. So from that perspective, I would like us to get there. What we have done for many years is encourage our lawyers to spend at least 50 pro bono hours a year, and to really recognize those hours, and put them at a par with sort of what we call billable hours, and to make sure they are recognized and valued as such. But there is clearly a huge increase, and I mentioned in my brief introduction, what I found extremely encouraging to see was that during the pandemic, our pro bono hours went up by 17%. There's also a level of concern there, I'll immediately admit, because overall the hours of lawyers have gone up quite dramatically, and I think that's the experience of many law firms during the pandemic, which on the one hand, one might think is good for business and good for the pro bono hours. I do worry, as many of us do, around the mental well-being, but that's a completely different topic. People are sitting at home, not commuting anymore, and spending so much time behind their computers doing work. But from a pro bono perspective and the increased number of hours, that is good. And I would like us to get to a situation that everyone does this as part of their job. I have to say, particularly with the younger generations, and I'm not quite sure where the cutoff is on that. I mean, I'm 55 and I've always been engaged on this, but you see a great desire of the younger generation of lawyers to be involved in pro bono activities, and really asking around, the social contribution, the societal contribution that large enterprises and large law firms like ours make. And that comes into the topic of including purpose, but also ESG. We talk about a lot of acronyms, and the SDGs, with the environment, social and governance, is another framework, particularly on the S side. And I find it very interesting, and I'm deviating a little bit of my answer, if I may. One trend and topic I find very interesting is around the energy transition, which is of course key to all our future, but that should be a just transition, which is one of the terminologies and provisions in the Paris Accord. And I think just transition really brings in the human rights element as part of that energy transition. And what I like about that, and that does come back to your question, Justice Robin, is that I think, supporting the SDGs should not just be a matter of pro bono and community work. It should go to the center and core of our business as much as possible. And together with Roger Lees, who's the chair of A4ID and who's a partner of mine, we're really trying to move the firm to more and more, as part of our responsible business, in everything we do and in our operations, be supportive of the SDGs. And the ESG framework is a framework that helps us get there, I hope.
Jeroen, thank you. And thanks for the deserved acknowledgement of the work of Roger Lees, if I may say so. Anjana, could I ask your perspective on this question as to whether pro bono is becoming part of being a lawyer and not just something that is a valuable but an add-on? And you're on mute, Anjana, at the moment. Thanks.
As litigation is increased, I think, the need for becoming a pro bono lawyer is also increasing. In fact, it is becoming more formalized now, in the sense that every court now has a list of lawyers who have volunteered to do pro bono work. And I agree with Mr. Ouwehand when he says, the younger set of lawyers, they are really volunteering, pro bono work very actively. And they think, that it is a part of the social commitment, the part of their being a lawyer is to do pro bono work. And at one time, the hesitancy was also of the clients who believed, that if a lawyer was not paid, he would not do work sufficiently well. But now, with the state bearing the expenses, that myth is now gone. And therefore, the state has somehow or the other helped, in pro bono work, where the belief of a client in distrusting a lawyer because he's not paid, that has vanished. And that is, one crucial thing where India is concerned.
Thank you. Thank you, Anjana, very much indeed. Could I pick up next? Something that comes very much from the remarks of Ian, but there's a reflection in the remarks from all of the panel members. Ian emphasized partnership, and related to that is the subject of coordination. Ian, looking forward, and in particular looking forward to a post-pandemic world, what more do you need to cause government, institutions, and the profession to work in a more coordinated way?
Yeah, so I think, just to start perhaps at the macro level, I mentioned at the start about the UK government being a significant aid donor, £10 billion this year. But the only way that we can really deliver aid effectively is through partnership, is through collaboration with the private sector, with civil society. Any government is not able to deliver programs of that magnitude and scale in the field, on the ground, without working with other partners. It would just be impossible. And I think it's really important as well. A couple of panelists have talked about the sort of lived experience. So really understanding the context in which we're working within a particular country, and it can be very different. And so what are the appropriate delivery mechanisms for our aid? Who are the right partners to be working with? Who has influence? Also understanding the political and security context. We certainly don't want to put any partners at risk from their activities in the field. And I think post-COVID, I think one of the difficulties that we've seen is even before the pandemic started, concerns that the human rights and rule of law space globally, the context was in a bit of a negative trend. And I think there's a concern that through COVID, as a couple of other panelists have mentioned, some governments using that as an excuse to close civil society space, to close space on rule of law. And so really making sure that as we come out of the pandemic, the principles of the SDGs, the Sustainable Development Goals, the principles of the UN Declaration on Human Rights, which all states are party to, really are promoted and really are adhered to in states, so that what we come out with after the pandemic is not necessarily going to be the place where we want to finish. And so I'm really concerned that about the trajectory, and the only way we can make a difference is by working with partners on the ground.
Ian, thank you very much. And if I take Ian's answer as from the vantage point of government in this question of partnership between government, institutions and profession, Could I ask Julia, from the vantage point of an institution, what she would say is needed to enhance that partnership as we come out of the pandemic?
Yeah, I just second everything you said. I think we can no longer have just this clear delineation between this is what the government does, this is what civil society does. I think we're all like working towards a common goal, which is to have a better recovery from the crisis. And we very much need the private sector to give jobs to women and to other vulnerable groups. And the government can only support the private sector if they have the right knowledge, the right information, the right data. And so, yeah, I think that's the partnership between, so I am at an international organization providing this data, doing this research, but of course it also comes from local organizations, universities that really need to be involved in this discourse. How can we build better and think about disadvantaged people, especially, and bringing them in, because otherwise no economy can come back to its full force.
Thank you, Julia. Whilst I've got you, could I bring in a question which is really for you, from Matt Carter in the audience. Matt invites an example of how data, especially data gathered in the course of the pandemic, has helped inform future change. Could you offer one?
Absolutely. I mean, let me circle back to some of the research that I mentioned earlier. We know how the pandemic is affecting women. We know that women are dropping out of the labor force at 4 times the rate of men because of these reasons, that women's jobs often are more vulnerable, are more affected by the crisis and the uptake in care work. And this is something that's very clearly coming out of data by organizations around the world that are collecting data on women's labor force participation. And in order to support working women, we also have seen that those economies that provide additional childcare benefits, either tax incentives or direct support, babysitting vouchers, longer opening of schools, really very different measures that can support childcare. That's incredibly beneficial to support working women. And that's where we have to keep supporting by not just keeping it to a pandemic emergency relief measure, but really thinking how can we build a more robust childcare industry overall.
Thanks, Julia. Can I come across to Anjana, because from the audience, Badani Upreti, who's in Nepal, has asked for views on how one can help lawyers understand the difference between pro bono contributions, which are without reward, and legal aid contributions, which are for reward, even though the reward may be modest. She indicates that in Nepal, there is amongst the lawyers a confusion between the two. And Anjana?
There is a difference between pro bono and legal aid, in the sense that when you get enlisted in the legal aid boards, what happens is that you get paid there. But pro bono means, you know, when you work without any rewards, nobody is really paying you for it. How do you prepare a lawyer for that? I think, you know, there is a need for sensitizing the students during their college years, why and how it is important and how difficult it is for an ordinary person to access justice, putting them in their places. When they understand, you know, how the system works, maybe they'll be more sensitive to it, and maybe they'll be more receptive to the idea of doing pro bono. Even though I believe, you know, that in every lawyer, no matter how mercenary he is, but in every lawyer's career, he's acted, in some way or the other in a pro bono capacity. Either it is advisory or actually appearing, for a certain client, because that just becomes part of your work, So since a client you've been, engaged by a lawyer and you've appeared 3 or 4 times, and the 5th time the client does not have money to pay you, and he comes to you and says, sir, I don't have any money to pay you. The lawyer will not say, okay, no, you've already paid me 5 times, but the 6th time also I need money. So the 6th time he may do it pro bono, even if he is, a very mercenary kind of a lawyer. This is, in a course of practice, I think also, the concept of pro bono builds up. But where pro bono, as as a social contribution is concerned, I think lawyers need to be sensitized on this point, how essential it is.
Thank you very much.
I've answered your question. I hope I've answered your question.
I think you've done extremely well, and I know that the member of the audience will be grateful. I'd like to go across to Joel, really for 2 purposes. Joel, I'd love to hear anything on the data point that I put to Julia, but would you follow that with any reflection on Anjana's point that a lot of the contribution to pro bono access to justice and rule of law has to start when we're educating our lawyers? Jeroen, over to you.
Thank you, Robin. The first one on data, and thank you for that. I just wanted to come back to that question because there's many sources of data, and Julia was referring to the data they have at the World Bank. We have data from academic institutions. I would just like to make a shout out in the context of, we're all working towards the same goal. Another NGO we work with, and I mentioned it before, is the Hague Institute for Innovation of Law. And I would encourage people to look them up. They also do quite a lot of data research in many countries and jurisdictions on access to justice and effectiveness of access to justice. And they have something called the data dashboard. And they use those data to then to set up justice task force in all these countries, often in a collaboration in partnership of civil society, government and private enterprises to try and drive change using those data. And they do that in particular by the use of technology. And we talk about technology a lot and whether that is a solution. And Supreme Court Justice and Anjana mentioned some of the difficulties there. But I think that is another example, if you're looking for a concrete example, the person who asked that question, for where data is being used to drive solutions. And then going to your second question around education and training for lawyers, it goes a little bit back to the discussion we had at the beginning, that I personally do think doing pro bono work, and I recognize the distinction with legal aid work, and in the early days when I started to do pro bono, I discovered that distinction in the sense that I was doing work which fell more in the bucket or category of legal aid, and then discovered I was getting in the way of lawyers who actually made their business doing legal aid work. So that was not helpful. So I recognize that distinction, but that is now well established in what we do. But I do think there is a huge learning experience in doing pro bono work and experiencing other types of work than what one might otherwise do, and get a broad and deep experience, and also often a very human element in the experience. I mean, if you are a finance lawyer doing derivative contracts for a major financial institution, then I'm not saying anything negative about that. That can be very interesting and complex work, but it's very different than doing pro bono work. And I think to be a rounded lawyer and get broad experience it should be part of the education. And as was also being confirmed, I am seeing increasingly a desire of our young generation of lawyers to really be involved. And I think it is upon law firms like ours and leadership in those firms to make sure that work is properly recognized and not put on second tier. And someone mentioned earlier, pro bono clients should, there's a concern that they would be, from the clients themselves, they would be not prioritized, so to speak, we make a huge effort to make sure that whenever you do any pro bono related work, it is valued in exactly the same way as if you're working for, one of our major paying clients, and that goes through everything. The scheduling, it not being pushed aside when something else comes along, and really allowing lawyers to do that and recognizing it. But it's a long answer, but I think it is very much part. It should be very much the training of any lawyer. I've done quite a lot of that work as a young lawyer, continue to do it, and I think it's made me a better lawyer. I think it's made me a better advisor and a better litigator.
Thank you very much. And I, for one, have no doubt that it will have made you better in the ways you've indicated and hoped. And I'm delighted that your reference that you continue to do this. I wondered if I could go to Ian on a point that has been commented on by some of the other panel, and it's that the question about technology in the future. This recognition that if justice systems switch across to technology, that might exacerbate some of the access to justice problems, but it might also provide some of the solution to access to justice problems. Ian, any reflection from yourself from a government development vantage point on that issue?
Yeah, it's a really interesting question, and not to duck it, but I think that the jury is still out on what the use of technology means. I think, as some of our other panelists have commented, there's considerable potential for the use of technology in supporting justice overseas. We've seen this in the UK, the use of the Nightingale courts to speed up the backlog of cases. And there have been other examples, for instance, in South Africa, trying to enable hearing digitally. We know that in Kenya, they've been using technology to try and help with land claims through the court system. So there's clearly potential. I guess I have two sort of caveats, though. I mean, the potential is enormous, but there is still a digital divide. I think some of the speakers have talked about this. There's still a gender divide on access to technology. And so technology by itself will not necessarily improve access to justice. You need to have, that technology needs to reach those who are claiming access to justice. And also, my department covers human rights, freedom of online access to technology. It's a contested space right now. So the idea of having open dialogues, open conversations, freedom of expression, unfettered access to the internet, that is contested, and it's increasingly contested. So I do see some risks as well that we need to overcome to ensure that technology really can have the impact that we want.
And without sort of putting you too much on the spot, Ian, looking again at the future, the post-pandemic world, and a world in which we're striving for enhanced rule of law and access to justice. If you are asked to consider proposals which would promote access to justice by developing, as part of that, the use of technology amongst the population, your reaction would be open-minded, or one that said, actually, we're in territory that is beyond what we're looking to support?
Well, I think I would sort of take you back to what I talked about at the start with my opening comments about open societies. And in order to really be able to benefit from the advantages from technology, you need to have media freedom, a free and fair, open civil society, functioning institutions. And those are some of the pillars that we talk about on open societies. So if all of that's working, then technology certainly does have great potential to increase access to justice. But by itself, not necessarily. So I guess I'm arguing that you need to sort of look at the holistic picture and ensure that the institutions and the environment in terms of human rights is really open and unfettered to ensure that the technology works.
Many thanks. I asked Julia earlier, I think, about any parallels between micro insurance, microfinance, and justice. And what is brought to mind has been a reference in some discussions of the future of pro bono and access to justice is how sometimes the presence of a mobile phone or two in a rural community can be a game changer. And I just wonder whether we might find the same as part of the future focus here. Let me move, if I may, with real thanks to some of the contributions that are coming up in the from the audience in the Q&A to look at the corporate dimension and the corporate dimension as we move forward post-pandemic in the context of rule of law. We've all heard, of course, and subscribed to the idea of corporate social responsibility, but maybe the future in a rule of law context is about that, yes, but also corporate responsibility, even apart from the social in the middle, and corporate responsibility in a context of climate change, environment, modern slavery. These are all mainstream issues for business. Is this a context in which, in fact, the lawyers and the courts, but will have a bigger role in relation to rule of law than ever in helping their clients to realize the scale of the corporate responsibility ahead? Thoughts on that? And I'll start with Jeroen, if I may, who did make a reference to just transition in the energy context. So your further thoughts, Jeroen.
Well, thank you very much for that question, because I had actually wanted to say something about that anyway. I do think there is, I mean, corporate social responsibility has been a term that's been around for a long time, but it has often been something which has been sort of on the fringe. You know, you do your business and on the fringe, you also do some corporate social responsibility or maybe pro bono work. Or I think it is moving more and more to the core of what businesses do. There's more and more, and I mentioned it in the context of our own business, to make sure that supporting the SDGs is something we do as part of our overall DNA in business. And you know, one of our 5 key principles in our own code of conduct is act responsibly, which very much goes to this theme. But I'm noticing more and more in discussions with clients that it goes way beyond being in compliance with the law. And it is, the net zero commitments are a good example of that. There is often not yet a legal obligation for a net zero commitment, although we have recently seen, it was 2 or 3 weeks ago in the Netherlands, my home country, a court decision against Shell that they have to reduce their carbon emissions by 45% by 2030, which is an interesting judgment because it singles out one enterprise, whereas others do not have the same legal obligations. So it's, as a lawyer, one can argue with it and look at it from different aspects, but it is quite telling. But I think there is a increasing understanding of the drive to move beyond mere compliance with law and do the right thing. And maybe I'm a glass half full type of guy, and you know, one could also be cynical around that, but I do really see a move There's also a move away from a pure shareholder model, which is very much the more Anglo-Saxon model, to a broader stakeholder model. We see regulations coming out of the EU whereby the environment is defined as a stakeholder, where the human right due diligence obligations are being increased. But I really see a further development in those discussions. Now, as part of my role, what I'm doing, I'm interviewing many business leaders around ethics and business and purpose. And the purpose discussion, I think, is real. It is more than just a flashy sentence on the website that looks good. And you see many businesses where it's really becoming more and more part of the DNA because of pressures from consumers, from customers, from shareholders, from employees, generational changes, from activist shareholders when it comes to net zero. So I think there is really a sea change going on. And I believe that is a key development coming out of the pandemic. And people talk about building back better, a term that I've been using as well. One of the associates in the team I work with said, actually, we should be using the word building better because I'm not sure we want to go back to much of what we had, which I thought was quite a nice way of looking at it. But I do really see a real development there in the corporate world. Without being naive, I mean, the world isn't all going to become rosy tomorrow, not at all. But I do really see a shift in the type of discussions we're having with our clients.
How very interesting. Something that will put the commercial firms' involvement at 2 dimensions, their contribution to where there's disadvantage, but they're also their contribution in the pursuit of their mainstream advice to help the corporate world adjust. Julia, your reflections on this point, especially from a context of the way in which the world over one can find some of the disadvantage to women being because of the way that the corporate world currently operates.
Yeah, I think that's an excellent point to the discussion, and I also feel encouraged due to my work and what I'm seeing at the World Bank. There is a much larger discussion now around responsible business, responsible programs. We're no longer just talking about economic growth at just the sake of economic growth, because of course that's always a danger that you would just, give any job to women or vulnerable people, which still may, help to lift out of poverty, but then you have other issues of exploitation and inequality. So I feel very encouraged that there's more and more discussion around social issues. The World Bank itself has a very strict environmental, social safeguards framework to programs and operations. And more programs that I'm seeing are informed by data around vulnerable groups and what it means to bring them in, this idea of having stakeholders from the entire society. And it really goes back to this work like ours. We're looking at the legal framework, and what we're seeing is that where there is a more robust legal framework that protects women, that protects other disadvantaged groups, the economic recovery is better. So human rights, women's rights are smart economics and promote a much more sustainable growth. And this also brings in, again, the idea of partnership. If we work together to highlight these issues, we can actually come forward with better informed decisions how to promote such sustainable growth.
Julia, thank you very much. Now we've only got 2 minutes to go, and I'm going to give 1 minute, if I may, to each of Anjana and Ian. And the question for them is to name one thing that they think needs our collective attention post-pandemic and where realistically a difference can be made. Ian, what would be your one thing?
So I think the thing I would wish to highlight is before the pandemic, there has been a squeeze at the global context on human rights and rule of law has not been good. So post-pandemic, I think what the COVID has exacerbated that trend. So post-pandemic, one thing I think governments need to ensure is that, and using sort of Jeroen's phrase, is not sort of building back better, ensuring that we build back in line with the principles of the SDGs that we have all signed up to. So hold us to account to deliver those SDGs by 2030, and that will be a good yardstick to measure us by.
Thank you, Ian. And Anjana, what would be your one thing that needs our collective attention post-pandemic?
I think, we all need to re-examine our own behavior, during the COVID times. The government's responsibility, the corporate responsibility, the social responsibility, how we have emerged as human beings, and whether at all we believe in the rule of law. Whether this COVID, this pandemic has been an excuse, to trample everybody's human rights. What is it exactly? We need to go back on that. And it is, Ian was absolutely right. None of us are going to be the same after the COVID as we were before. So, much has changed. So we need to look back and see what was wrong, what went wrong. I mean, there was something, which is psychologically upsetting all of us, so much so that we've forgotten to be human beings.
And Anjana, thank you very, very much indeed, because that's the platform for, I think, our collective recognition that there's an opportunity to be better. There's an opportunity to be better with the benefit of the reflection you have encouraged. So let's look forward to that. The conference over the next 2 days, I know, will build out some of the ideas, but absolute heartfelt thanks to Anjana, to Julia, to Ian, and to Jeroen. It's been a privilege to listen to you. Thank you very much. And now I think back to Yasmin.
Yes.
Thank you very much, and thank you for moderating. Thank you.
Thank you indeed, Robin.
Thank you.
Thank you for your actually superb chairing and for your gentle but irresistible interrogation of our esteemed panel. Thank you for helping to tease out some of the very thorny challenges that we are facing. As always, you've helped us do this by tackling these issues with exceptional clarity and aplomb. And I'd also like to thank our panelists, Anjana, Jeroen, Ian, and Julia, for responding to our judges' interrogations so adroitly for our benefit. I think this has been a wonderful exchange, and it certainly concludes this session, but I cannot help but comment that this is just the beginning of our audience's participation in the conference, as they've come up with some really great questions, so keep them coming. Now, I just want to apologise. I understand that there was a glitch in the machine, talking of our technology, which meant that some of you could only join quite late on. So fortunately, you didn't miss much because it was only me talking and not the other speakers. So apologies for that, but we are now, hopefully, everyone is joining as we'd hoped they would do. Now, the next session we have is for our Spark Talks, which follows immediately after this. And this is led by social justice actors who are truly inspiring change around the world. And then we'll have our main panels, which will convene in 20 minutes. And you will therefore have the difficult choice to make. Session 1 is International Partnerships for Sustainable Change. And that's about how we work together internationally to overcome challenges in the rule of law. And our other session, which is session 1B, Coordinating Pro Bono, Strategic Insights from Around the World. And that's about how different organizations around the world deploy pro bono. Now, all the links to these panels will be found in the chat function. And if you need to know anything more about the schedule of the conference, check it out on the conference website that also can be found in the chat function. So I'm going to close this session. I think it's been amazing, and I look forward to joining you very soon. And I do hope you enjoy the rest of the conference. Thank you.